I'm Paul Smith. I practice law in Washington, D.C. at a firm called Jenner and Block, and I'm on the ACS board. We're in a very interesting moment in terms of the gay rights movement as the Supreme Court's about to decide these two big cases, the Perry and Windsor case. And there is an interesting divide even among people who care very much about equality, about whether the court should kind of go for the home run in Perry and say that all distinctions between same-sex couples and other couples across the country ought to be eradicated right now, or whether there would be better perhaps for the court to do a more limited set of holdings in the two cases. It's even possible for the cases to kind of go away with procedural problems that were raised in both of them. My expectation is that the court will probably reach the merits in the DOMA case and hold it unconstitutional. It's possible, though, that there may not be 5 votes to hold it unconstitutional under the Equal Protection Clause. Instead, Justice Kennedy seemed to be interested more in federalism arguments. My own view about that is that would be fine. If the law goes away, the law goes away, and a whole lot of happy couples will be able to be treated as fully married by their own federal government, and that would be huge progress. In terms of Perry, if I were a justice, I would probably not decide all 50 states have to marry same-sex couples this year. The change that's happening in public opinion is so dramatic. The political changes that are sweeping the country are so dramatic that I think the court is part of that process. It played a great role in getting it started with the Lawrence decision and others, but they have ways that they could be part of it without taking it all the way to the finish line, and I think they will prefer to do it that way, and in fact I don't tend to disagree with them. I know many younger people who think that was crazy, that there's no reason why the court shouldn't do what's right now, and I certainly think the right answer in the long run will be that there should be marriage equality mandated by the federal Constitution. But I think they are much more likely to find a more narrow ground for decision, either saying there should never have been an appeal and Judge Walker's decision should stand, or perhaps an equal protection ruling grounded more on the particular circumstances of California.